Welcome to the Deep Dive, the place where we take complex topics, stack up the sources, and extract the knowledge you need quickly. Today, we are wrestling with a really fundamental legal dilemma. It kind of pits public safety against the reality of childhood development.
It really is a classic tort law puzzle, isn't it? Negligence requires us to measure conduct against a standard yardstick, the reasonable person. But, well, what happens when the person causing the harm is, still learning the ropes, so to speak?
Exactly. Can we really expect a 13-year-old to meet the same standard of care we demand from a fully mature adult? This deep dive is all about finding that legal line between, kids being kids and activities that are just inherently dangerous. We're going to focus hard on a key case, Robinson v. Lindsay from 1979, to see exactly where courts draw that line.
Right. And we've structured this session to give you a really practical understanding. We'll start with the traditional standard care for children, which is quite flexible. Then we'll pinpoint the really crucial exception, the adult standard, which kicks in for certain activities. And finally, we'll walk through that landmark case using the FIRAC method, and then pull it all together into a straightforward issue-spotting framework for you.
Okay, before we lay out the general rule, let's use the basic facts from Robinson v. Lindsay to kind of set the stage. Because this scenario really shows why that general standard can sometimes, well, break down. The whole thing started after a pretty bad injury involving two minors. What exactly happened there?
Okay, so the case involved Kellyanne Robinson. She was 11 years old at the time. She was very seriously injured when the driver, 13-year-old Billy Anderson, was operating a snowmobile and braked suddenly. The accident resulted in Kellyanne losing the full use of her thumb. It was quite severe.
And this snowmobile Billy was driving, what kind of machine are we talking about? Was it just like a kid's toy?
Oh, definitely not. It was a 30-horsepower snowmobile. This thing was powerful, capable of speeds up to 65 miles per hour. Now, Billy was apparently only going about 10 to 20 miles per hour when the accident happened, but the vehicle itself, it had inherent danger built in.
Right. And when this case first went to trial, the jury was told to treat Billy like a kid, basically using a very lenient rule.
Yeah.
That's the historical default, isn't it? So let's back up a bit. Before we had things like 30-horsepower snowmobiles buzzing around, what was the standard rule for judging a child's negligence?
Well, historically, courts really understood that holding a young child to an adult standard would be, as one court famously put it way back in the 1890s, a monstrous doctrine. So they adopted a much more flexible standard, one that acknowledges, their limited capacity and experience.
Okay, what are the specifics of that flexible standard? What does it look at?
The general rule, the default, is that a child is only required to exercise the degree of care that a reasonably careful child of the same age, intelligence, maturity, training, and experience would exercise under similar circumstances.
That sounds, incredibly forgiving. So if a 10-year-old is just acting like other 10-year-olds, maybe doing something a little risky, and someone gets hurt, they could potentially walk away with no liability.
Yes, they absolutely could, provided, of course, their conduct wasn't negligent when compared to peers with similar experience and maturity. And the policy thinking behind this is really important. The law wants to allow children room to be children, engaging in typical youthful activities, playing, running, climbing trees. These things naturally involve some risks, some mistakes. We want them to grow and develop without constantly worrying about adult-level lawsuits.
That makes a lot of sense for things like, tag, or maybe throwing a baseball around in the park. But the facts in Robinson clearly involve something much, much riskier than a playground game. So when did courts start thinking that this flexible standard was creating, as you mentioned, apparent injustice for the public? When did things shift?
That shift really started gaining steam in the mid-20th century. As society filled up with more powerful machines, cars, boats, farm equipment, the courts essentially had to carve out an exception. The reasoning was, look, when a child chooses to engage in an activity that's normally for adults, especially one that poses a serious physical threat to others, they're effectively stepping out of the zone of childhood protection for that activity. They're volunteering for a higher standard.
Okay, so what's the rule then? What's the specific trigger that flips the switch to the adult standard of care?
The adult standard applies when the activity the child engages in is considered inherently dangerous. And the courts have been particularly clear this applies when it involved operating powerful mechanized vehicles. The law basically says the moment you get behind the controls of a machine that can cause grave harm, your age becomes irrelevant for setting the standard of care.
I see the shift in policy there. You're saying the law starts prioritizing public safety over the child's individual development once the potential danger gets high enough.
Precisely. It's about protecting the public from unreasonably hazardous behavior and also, frankly, discouraging immature individuals from messing around with things that can cause serious injury or death. A 30 horsepower snowmobile doesn't care if the driver is 13 or 30 when it crashes. So the minimum level of care required has to be the adult one.
Okay, this is where it really comes together. Let's formally analyze how the court applied this exception in that key case, Robinson v. Lindsay. First, let's nail down the legally dispositive facts. What were the absolute key facts the appeal court focused on?
The crucial facts were these. 1. 13-year-old Billy Anderson was operating a heavy, powerful 30-horsepower snowmobile. 2. This was a type of motorized vehicle generally requiring adult skills. 3. His operation of this vehicle directly caused the severe injury to 11-year-old Kellyanne Robinson. And 4. The trial court had initially used the child standard, but then ordered a new trial using the adult standard. That's what was being appealed.
Right. And what was the core legal issue the Supreme Court of Washington had to decide? The central question.
The single narrow issue on appeal was this. Should a minor who is operating a powerful, inherently dangerous, mechanized vehicle specifically, a snowmobile in this case, be held to the standard of care we expect from a reasonable and prudent adult?
Okay. And what rule did the court lay down in response to that issue?
The court established a clear rule. When a child engages in an activity that is inherently dangerous, especially one involving powerful motorized vehicles typically used by adults, that child must be held to the adult standard of care. They explicitly rejected the defense's argument that Billy should get a pass because maybe other 13-year-olds would have been just as careless on that snowmobile. That wasn't the point anymore.
Let's dig into the court's analysis. How do they justify making this jump from the flexible standard, which is normally protective of minors, to this much stricter adult standard?
Their reasoning was almost entirely focused on public safety and the nature of the machine itself. They talked about the hazards involved in operating powerful motors in, quote, modern life. They looked back at earlier cases, like one involving a motorboat, and basically said, letting powerful machines be operated by immature individuals who might not meet even a minimum standard of adult care poses an unacceptable risk to everyone else.
Did they draw parallels? Did the court compare snowmobiles to other sorts of dangerous activities?
Oh, absolutely. They pointed out that the adult standard had already been applied to minors operating things like tractors, motorcycles, even gasoline-powered mini bikes, and, of course, automobiles. They brought the snowmobile into that category by highlighting the sheer number of them, millions in operation back then, and the accident statistics. They noted hundreds of casualties occurred each year, especially involving inexperienced operators. The machine itself, its power and potential for harm, demanded an adult level of competence and attention.
And so, the final conclusion of the case, what was the bottom line?
The court affirmed the trial court's decision to grant a new trial. The holding was unmistakable. Because the 13-year-old was operating a powerful motorized vehicle, he had to be judged against the standard of care expected of a reasonable and prudent adult, not against other 13-year-olds.
That really clarifies the rule. Okay, to help everyone listening really lock this in, let's try a couple of quick, visceral hypotheticals to test this line. First one. Picture a classic neighborhood scene. A 12-year-old is playing baseball, maybe trying to impress friends. They wind up, throw a fastball wildly, it sails past the catcher, hits a 10-year-old spectator standing nearby, shatters their glasses, causes some eye damage. Based on what we've discussed, what standard applies there?
Okay, in that scenario, the traditional child standard applies. Throwing a baseball, even carelessly, is seen as a typical childhood activity. It's part of growing up, learning coordination. While it unfortunately resulted in injury here, it's not generally classified as an inherently dangerous activity like operating heavy machinery. The policy goal is to let kids be kids in these contexts.
Right, so the law allows some leeway for learning social skills, coordination, things like that, but draws a line at operating powerful machines.
Yeah.
Okay, second scenario. Let's make it more directly related to the Robinson rule. Imagine a 14-year-old, maybe grew up on a farm, experienced for their age. They're driving a huge, say, 150 horsepower combine harvester during harvest season. They get distracted for just a second, maybe check a text on their phone, they veer slightly off course, and badly injure a worker in the field. What standard applies now?
That triggers the adult standard immediately, no question. The sources we discussed, like the case involving a tractor, make it clear that operating heavy farm machinery falls into that category of inherently dangerous activities involving powerful mechanized vehicles. The sheer size and power of that combine mean even a momentary lapse poses a severe inherent risk. That risk demands an adult level of competence, regardless of the driver's age or even their experience level relative to other teens.
Got it. So that distinction, focusing on the inherent danger of the activity or the machine, rather than the specific maturity or capacity of the child operator, that really is the core takeaway from Robinson v. Lindsay. So connecting this all back for someone, say, facing an exam or trying to analyze a real-world situation, can you synthesize these rules into a practical, actionable tool for spotting this issue?
Absolutely. If you encounter any negligence claim where the defendant is a minor, you really need a clear step-by-step diagnostic checklist. It prevents you from applying the wrong standard, which is a common mistake.
Okay, lay out the diagnostic tool for us. What are the steps?
Okay, here it is. Step 1. Spot the minor defendant. First, just identify. Is the person accused of negligence legally a minor? And is the claim about negligence? Simple check. Step 2. Start with the default. Always begin here. Was the child doing something typically associated with childhood? Playing, riding a bike normally, that sort of thing. If yes, your starting point is the flexible child standard. Judge them against a reasonably careful child of the same age, intelligence, maturity, training, and experience. Step 3. The critical exception check. Now ask the key question. Was the minor engaged in an inherently dangerous activity? Specifically, does it involve operating a powerful motorized vehicle? Think snowmobiles, motorboats, cars, motorcycles, tractors, combines, maybe even certain types of industrial equipment. Step 4. Apply the correct standard. This is the final decision point. If the answer to step 3 is yes, it was an inherently dangerous activity involving a powerful machine, then you must apply the strict adult standard, the standard of a reasonable and prudent adult. If the answer to step 3 is no, it was not that kind of high-risk motorized activity, then you stick with the flexible child standard from step 2.
That diagnostic framework is incredibly helpful,
Yeah.
really clear. We've seen how the courts try to balance, giving kids space to grow and learn with the absolute need to protect the public when powerful, dangerous machinery gets involved.
Right. And it really leaves us with an interesting question to think about moving forward, especially for you listening. As technology keeps advancing, think about complex robotics, powerful drones, maybe even sophisticated autonomous vehicles that younger people might operate or interact with. At what point does the law shift its focus entirely to the inherent danger of the technology or the machine itself, regardless of the operator's age, even if using that technology becomes common for younger people? Does the normally for adults only aspect eventually fade away if the danger remains high?
Definitely something to mull over as technology continues to blur those lines. Thanks for diving deep with us today.